Welcome to Employment Law This Week. I'm George Whipple. When it comes to trade secret and non-compete litigation, we often think first about injunctive relief. But these cases can also result in massive damages awards. That topic is the focus of this week's episode of Spilling Secrets, Epstein Becker Green's podcast series about trade secrets and non-compete law. Epstein Becker Green's Erik Weibust tells us about the current state of trade secret litigation.
You would be amazed at how many viable trade secret claims are never pursued, either because the victim of misappropriation simply does not have the funds to take on a much larger opponent, or there is not the institutional or investor will to spend what could be millions of dollars in legal fees, even with the possibility of a 10x or greater return.
The Defend Trade Secrets Act, the Uniform Trade Secrets Act, and New York common law all offer ways to recoup money lost due to trade secret misappropriation. Epstein Becker Green's Jim Flynn tells us more.
Basically, under those three elements of law, you can get your actual damages, what you actually lost by having your trade secret misappropriated. You can get that in various forms. It can look like a reasonable royalty. It can look like outright damages. You could also get attorney's fees in certain cases under the two statutory laws. You can get what they call exemplary or punitive damages under those laws.
For clients who wish to pursue damages but lack the means or desire to fund the process themselves, there are other options available. For example, some funding companies will finance trade secret litigation in exchange for a multiple or percentage of damages. Other companies are even starting to offer trade secret insurance that protects against theft of trade secrets. Jim views trade secrets as capital assets of the company that can be amortized. He recommends analyzing trade secrets to evaluate a company's decision to pursue damages in trade secrets litigation. And it's important to remember that other provisions have value as well.
You want to make sure that you can get equitable or injunctive relief and that you structure your contracts in such a way that one doesn't necessarily preclude the other, and that you can eliminate things like the necessity of posting a bond or other things of that nature.
The Spilling Secrets team continues the conversation in this week's episode, covering the wisdom of identifying trade secrets up front and much more. Subscribe to the Employment Law This Week feed wherever you get your podcasts to hear the full audio episode and to catch all future editions of the Spilling Secrets series. Thank you very much for watching, and we'll see you next time.